If you were born before 1975 and you are renting right now, your landlord may have been breaking the law without you ever knowing. And the most shocking part of everything I'm about to tell you is that some of this illegal behavior may have been going on for years. Over 11 million renters across England are now protected by the Renters' Rights Act 2025, and that protection absolutely includes you regardless of your age. But renters who have been in their homes for many years are among the most likely to have experienced illegal landlord behavior without ever realizing it. Today, I am going to show you exactly what your landlord has been doing illegally, and more importantly, exactly what you can do about it right now. The Renters' Rights Act 2025 came into full force on the 1st of May 2026, and it applies to every tenancy in England without any exceptions. It does not matter whether your tenancy started last year or 20 years ago, these new rights apply to your home completely and immediately today. And it does not matter what your old tenancy agreement says, because clauses that contradict these new rights are completely void and legally unenforceable against you. Let us start with the first illegal thing your landlord may have been doing, and this one affects thousands of long-term renters right across England today. The first illegal thing is serving you a Section 21 no-fault eviction notice after the 1st of May 2026 under any circumstances whatsoever. Section 21 was the legal tool landlords used for decades to remove tenants without any reason, and it has now been completely and permanently abolished in England. Any Section 21 notice handed to you on or after the 1st of May 2026 is completely invalid, and your landlord is breaking the law by using it. Many older renters who have lived in their homes for years received these notices thinking they had no choice but to pack their bags and leave immediately. If that happened to you after the 1st of May 2026, you did not have to leave, and you may have grounds to take action against your landlord now. Your landlord can now only end your tenancy by proving a specific legal ground for a judge in a court of law under the Section 8 process. If they served you a Section 21 after the 1st of May 2026, contact Shelter or Citizens Advice immediately, because that notice is completely and totally illegal. The second illegal thing many landlords have been doing to long-term renters is using old break clauses from pre-existing tenancy agreements to force tenants out illegally. If your tenancy agreement signed before May 2026 contained a break clause, your landlord cannot use that break clause to end your tenancy anymore. Break clauses in existing tenancy agreements are now completely void under the Renters' Rights Act, and your landlord cannot activate or enforce them against you today. If your landlord has tried to activate a break clause from an old tenancy agreement since the 1st of May 2026, they may be breaking the law. The third illegal thing is telling you to leave because your fixed-term tenancy has reached its end date on the contract you signed years ago. All fixed-term tenancies in England automatically converted to rolling periodic tenancies on the 1st of May 2026 with absolutely no action needed from you at all. If your old contract has an end date on it, that end date now means absolutely nothing, because your tenancy rolls on indefinitely with no end date. Many older renters have been told by landlords that their contract has ended and they must leave, when in reality the law says they can stay permanently. If your landlord told you to leave because your fixed term ended after the 1st of May 2026, you did not have to go and should seek advice now. The fourth illegal thing is raising your rent more than once in any 12-month period, which some landlords have been doing aggressively to force older renters out. Under the Renters' Rights Act, your landlord can only increase your rent once per year, and they must give you at least 2 months written notice first. That notice must be given on an official Section 13 form, and an informal letter, text message, or verbal notice from your landlord is not legally sufficient. If your landlord has raised your rent more than once in the last 12 months, that extra increase may be unlawful and you can formally challenge it today. If you received a rent increase without the proper 2 months written Section 13 notice, that increase may also be invalid and you do not have to pay it. And if you believe any rent increase is above the current local market rate, you have the right to take it to an independent tribunal who will decide the fair amount. The fifth illegal thing is demanding more than 1 month of rent in advance, which many landlords have routinely done to older renters moving into new properties. Under the Renters' Rights Act, your landlord can only ask for a maximum of 1 single month of rent in advance when you start a new tenancy today. Demanding or accepting more than 1 month up front is now defined as a prohibited payment in law, and your landlord faces serious financial penalties for breaking this rule. If a landlord demanded excess advance rent from you when you started your current tenancy, you may be entitled to report this and have the excess money returned. The sixth illegal thing is refusing to rent to you or treating you less favorably because you receive housing benefit or have grandchildren or children living with you. The well-known no DSS ban that appeared in rental advertisements for decades has now been completely and permanently abolished under the Renters' Rights Act as of May 2026. Your landlord cannot reject your application or treat you less favorably because you receive any form of government housing support, including housing benefit or universal credit. They cannot discriminate against you because of children or grandchildren living in your home, and if they have done so, you have grounds to make a formal legal complaint. The seventh illegal thing is refusing your request to keep a pet in your rented home without providing a specific, legitimate, and objectively reasonable justification for that refusal. For years, landlords imposed blanket no pets policies with no discussion allowed, but under the new law, you have a legal right to formally request to keep a pet. Your landlord must properly consider your request and must give you a valid reason if they refuse, and if they do not, you can challenge their refusal legally today. Now, here is something that many older renters do not realize, and it is critically important for understanding exactly what illegal behavior your landlord may have committed against you. Every single one of these illegal actions is actionable, meaning you can formally report your landlord and, in many cases, claim money back for what they have done. A landlord who served you an illegal Section 21 after May 2026 faces a civil penalty fine of up to £7,000 from the local council immediately. A landlord who repeatedly breaks the rules faces a civil penalty of up to £40,000 and, in the most serious cases, an unlimited criminal prosecution fine. And if your landlord has broken certain rules during your tenancy, you may be entitled to apply for a rent repayment order to reclaim rent you have already paid. A rent repayment order allows you to apply to a tribunal and potentially recover months or even years' worth of rent paid during illegal landlord behavior today. The rent repayment order maximum has been doubled under the new law, and repeat offenders are required to pay back the full maximum amount with no discretion allowed. Here is your complete action plan based on everything you have heard in this video, and please take each step seriously because this is your home and your money. First, if your landlord has served you a Section 21 notice since the 1st of May 2026, contact Shelter or Citizens Advice immediately because that notice is illegal. Second, if your landlord has tried to activate a break clause or told you to leave because your fixed term ended, you do not have to go, so seek advice now. Third, if your rent has been raised more than once in the last 12 months or without proper Section 13 notice, document everything and contact Citizens Advice today. Fourth, if your landlord has ever demanded more than 1 month advance rent from you, report this as a prohibited payment to your local council enforcement team immediately. Fifth, if you have been refused housing or treated badly because of benefits or children, contact your local council or Citizens Advice to make a discrimination complaint today. Sixth, go to Gov.uk and check whether your landlord provided you with the official Renters' Rights Act information sheet, because failing to do so carries a £7,000 fine. Seventh, check your eligibility for a rent repayment order at Shelter.org, UK, or with Citizens Advice, because you may be entitled to reclaim significant amounts of money already paid. And as a renter born before 1975, please also use the free benefits calculator and entitled to UK to check whether you are claiming every housing benefit you are entitled to. Many older renters are significantly underclaiming their housing support, and a simple 5-minute check today could reveal hundreds of pounds of additional entitlement every single month. If you are approaching state pension age, check pension credit eligibility immediately, because pension credit opens access to a wide range of additional free benefits and support payments. If you receive pension credit, you may also be entitled to housing benefit, council tax reduction, free dental treatment, free glasses, and a warm home discount all at once. Renters born before 1975 who have experienced any form of landlord discrimination or illegal behavior have specific legal remedies available right now, and you should not hesitate to use them. The law is explicitly clear that your landlord cannot use your tenancy agreement to take away any of these rights, because any such clause is automatically void and unenforceable. Even if you signed a document that appears to waive some of these rights, that waiver is completely invalid, and your full legal protections remain in place regardless. Never let your landlord tell you that these rules do not apply to your old tenancy, because they do apply, and they applied from the very 1st of May 2026. Keep records of every communication with your landlord, including text messages, emails, letters, and notes of verbal conversations, in case you need evidence of illegal behavior later. The more evidence you have documented, the stronger your position will be when reporting to the council or making a rent repayment order application at tribunal today. Citizens Advice at citizensadvice.org, UK, and Shelter at Shelter.org, UK, both offer completely free advice and support for renters experiencing illegal landlord behavior of any kind right now. The Gov. UK website at gov. UK Guidance. Renters' Rights Act Overview for Tenants contains the full official guidance confirming all of these rights are yours and apply to your tenancy immediately. Your local council now has dramatically enhanced powers to investigate landlords, including accessing bank statements, financial records, and correspondence to uncover illegal behavior efficiently. This means landlords can no longer hide their illegal actions because local councils have the tools, the funding, and the legal authority to find them and fine them heavily. Share this video right now with every older renter you know, because most people born before 1975 who are renting have absolutely no idea about these rights at all. Your family members who rent, your friends who rent, your neighbors who rent, they all deserve to know that their landlord may have been breaking the law against them. If you found this video helpful, please like it right now because it genuinely helps more older renters find this critical legal information exactly when they need it most urgently. Subscribe to UK Housing Alert and hit the notification bell so you never miss an important update about housing law and your rights as a renter in England today. We cover housing law, landlord rules, tenant rights, and benefit changes every single week in plain, simple English so every renter always knows exactly where they stand legally. You have been renting and paying your rent faithfully, and the law now says that your home is protected and your landlord cannot break these rules against you anymore. Born before 1975 and renting right now, the law is firmly on your side, and it is time to make sure your landlord knows it too starting today. UK Housing Alert is here every single week, making sure every renter in England, including you, knows their full legal rights and exactly how to enforce them effectively today. If you have lived in your rented home for more than 5 years, your landlord has had more opportunity to break these rules, and you should check each one carefully now. Long-term renters are particularly vulnerable to fixed-term and break clause abuses, so if you have a long tenancy, check your contract for any clauses your landlord may misuse. If your tenancy agreement contains clauses referencing Section 21 or fixed-term end dates, those clauses are now void, and your landlord cannot rely on them at all today. Older renters who have experienced multiple rent increases in 1 year should document each one with dates and amounts and report this to Citizens Advice immediately for guidance today. If your landlord has used aggressive rent increases to try to push you out of your long-term home, this is a tactic that is now much harder for them legally. Renters who have experienced illegal harassment by their landlord, such as changing locks or removing belongings, should contact the council immediately, as this carries up to a £40,000 fine. If you feel your landlord has been trying to make you leave through intimidation or harassment, document every incident and report it to your local council enforcement team right now. Older renters who have never seen their landlord register on the private rented sector database when it launches should check compliance because unregistered landlords face serious fines. When the private rented sector database launches later in 2026, you will be able to check whether your landlord is properly registered and compliant with all their legal obligations. An unregistered landlord may also be prevented from using certain Section 8 possession grounds, so registration compliance directly affects your security of tenure in your rented home. If your landlord has never joined the Landlord Ombudsman scheme, when it becomes mandatory, they face fines and enforcement action that you as their tenant can trigger by reporting them. Renters who have experienced poor property conditions, including cold homes, leaking roofs, or faulty heating, should know that landlords now face stricter obligations to maintain decent home standards. If your property does not meet the decent home standard, your landlord is now required to bring it up to that standard under the new private rented sector provisions. Failing to maintain a decent home is not just unpleasant for you as a tenant, it is now a compliance failure that your local council can investigate and fine your landlord for. Renters in older properties, particularly those built before the 1980s, should specifically check for damp, mold, and structural issues because OAB's law requires landlords to fix these urgently now. If your landlord has known about damp or mold in your property and failed to address it within the required time frame, they may already be in breach of OAB's law provisions. An OAB's law breach gives you grounds to make a formal complaint to your local council, who can issue a repair order and fine your landlord for non-compliance today. Older renters in properties with poor energy efficiency should be aware that energy performance requirements for rental properties are being strengthened, and your landlord has obligations to improve the property. If your home is cold, drafty, or expensive to heat because your landlord has not invested in insulation or efficient heating, you should seek advice about your rights now. Renters born before 1975 who are on fixed incomes or pensions should particularly check housing benefit, pension credit, and universal credit housing entitlement using the free calculators available today. Every pound of housing benefit you are entitled to but not claiming is money leaving your pocket every single month, so please check your entitlement at entitled.co. UK right now. If you have been renting for many years and your income has changed significantly, your benefit entitlement may also have changed, so always recheck your entitlement whenever your circumstances change. A change in household composition, income, health, or housing costs can all affect what you are entitled to claim, so use the free calculator after any significant life change today. If you have received any correspondence from DWP about moving from legacy benefits to universal credit, please act on it immediately because the migration deadlines are real and urgent for you. Missing a UC migration deadline means losing both your existing benefits and the transitional protection top-up payment that preserves your income level, so act on any migration notice today. The Entitled to Co. UK and Turn Tuis. Org. Calculators are completely free to use and take only 5 minutes, and the results could reveal significant unclaimed money that is rightfully yours today. Remember that every right described in this video exists to protect you specifically, and the law does not require your landlord's cooperation or agreement for these rights to apply to you. These protections exist whether your landlord acknowledges them or not, whether your tenancy agreement mentions them or not, and whether your landlord likes them or not, because they are the law. Stand firm in your home, know your rights, document everything, report violations, and never let any landlord tell you that you have fewer rights than the law actually gives you. The era of renters living in fear of their landlord is over in England, and for older renters who have lived through decades of insecurity, that change is now real and permanent. Your home is your right, your security is protected by law, and UK Housing Alert is here to make sure you always know exactly what that means for you today. Born before 1975, renting in England, and fully protected by the strongest tenant rights this country has ever seen. Know your rights and never let anyone take them away. Subscribe to UK Housing Alert today, because every week brings new information that could protect your home, your money, and your rights as a renter in England.